JP Morgan Chase Bank versus Arnold Chavez appearances?
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right. So last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right. So, Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank.
We begin with the narrator introducing today's spectacle, multiple sovereign citizens making appearances in courtrooms, showcasing their classic pseudo-legal tactics. The first case takes us to Michigan, where a man claiming to be an American state national tries to dodge debt by separating himself from his straw man. This is a familiar scam where someone insists they don't owe money because it was lent to a legal fiction, not the living person. The narrator sets the scene with a blend of irony and curiosity, ready to show the audience how this argument crumbles. The case name is read aloud: JP Morgan Chase Bank versus Arnold Chavez. As appearances are logged, the judge asks Mr. Chavez to turn on his camera and confirm his identity. It's a typical virtual court start, but one that promises plenty of drama. The stage is set for a clash between banking law and fantasy legal theories. The narrator prepares viewers to see reality collide with these bizarre claims.
What is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
That's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is...
The judge immediately asks about interrogatories' written questions that had to be answered within 10 days. The bank's lawyer admits the answers were prepared, but accidentally not sent on time, and claims he emailed them just that morning. Meanwhile, document production had been handled earlier without issue. The judge turns to Mr. Chavez to confirm if he received everything, but Chavez says no, he hasn't seen those answers yet. There's clear frustration as Chavez explains he hasn't checked his email. This moment highlights classic procedural tangles in debt cases, but it's also setting up Chavez's larger tactic of claiming confusion. The court is trying to verify if the rules were followed fairly while ensuring everyone has what they need. The bank's attorney insists the essential records were produced. Chavez counters that he didn't get them in the time frame given. It's a small but important step toward exposing his later sovereign citizen defenses.
I'm not buying that. No. Listen
Okay.
to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. Where did I? 1 second here. I have them.
No, wait a minute. December 19th, there's a problem.
Okay. It's gonna have to be January 9th.
The Chavez's questions quickly shift from normal debt discovery to demanding Chase Bank's internal accounting records. The lawyer explains that while Chavez got his own account statements, he's asking for internal corporate records he's not entitled to see. The judge listens patiently as this demand is clarified, revealing it's overly broad and not specific. The narrator jumps in to highlight the absurdity, comparing it to a sovereign citizen once trying to subpoena millions of voters. It's meant to show how these defendants overreach in discovery to create delay or appear sophisticated. Chavez's strategy is clear: ask for documents he knows they can't or won't provide to manufacture a defense. The judge recognizes this isn't a valid approach. The bank's lawyer sticks to the facts, reiterating that all relevant personal documents were shared. This exposes how sovereign tactics often rely on confusing or stalling the process, not genuine defense.
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674, the Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this?
Pressed to explain his defense, Chavez claims he needs to verify accuracy of the actual accounting. He insists it's not that he refuses to pay, but wants to confirm what he owes. The judge counters with the clear record. his last payment date and exact amount owed. Chavez tries to argue that he didn't get the answers in time, but he doesn't deny using the card or owing money. The judge corrects him firmly. The issue is whether he had the card, used it, and failed to pay. Chavez's defense crumbles into vague legal theory about wanting evidence and checking accounting standards. The narrator notes how this shows classic sovereign citizen playbook behavior, pretending the debt is imaginary or miscalculated. This part highlights the reality that the legal system deals with facts, not personal theories. Chavez can't produce anything that changes the simple truth of the debt.
I'm setting a date. So what, do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached.
Chavez then unveils his real sovereign-style defense. He claims he is actually the lender, suggesting the bank owes him money. He argues his personal signature or security created value for the loan, a typical pseudo-legal argument. The judge interrupts, pushing him to stay on topic. He signed for the credit card, used it, and didn't pay it off. Chavez rambles about cash equivalents and accounting principles he doesn't truly understand. The court keeps pulling him back to the actual question of debt on his account. The narrator explains this is a well-known sovereign citizen myth where people think their signature magically funds loans from secret accounts. It's clear the judge has heard this before and isn't buying it. The bank's lawyer prepares for a motion for summary disposition, seeking a quick ruling. Chavez's elaborate theory is shown for what it is, smoke and mirrors, as the discussion wraps up. The court schedules a hearing for the bank's motion for summary disposition. This is the legal step that can end the case quickly if there's no valid defense. They first look at December 19th, but move it to January 9th due to scheduling needs. The judge is clear and patient, ensuring everyone knows the timeline. The bank's attorney says he'll file the motion promptly and serve Chavez appropriately. Chavez doesn't object further but seems overwhelmed by the procedure. The narrator uses this moment to underscore the gap between Chavez's complicated sovereign theories and the simple, boring reality of court scheduling. It's a great example of how courts handle these situations with calm, structured processes. Even when defendants bring in bizarre arguments, the law moves on. The scene closes with the judge confirming dates and instructing both sides clearly. Chavez is now on the clock to respond meaningfully. Clip next up. We jump to Chavez's other court appearance. Same day, same docket. But this time, Discover Bank is suing him over a different credit card debt. The narrator sets the stage, highlighting the absurdity of someone using the same defense in multiple suits. The judge asks for appearances, and Discover's lawyer introduces himself. Chavez once again confirms his name on the record, this time seeming a little more subdued. The judge notes that there was a previous hearing where Chavez failed to appear because of internet issues. Chavez explains, Xfinity was down in his area, and he even received a billing credit for the inconvenience. The court accepts that this is a valid excuse, but the judge still needs to know, does Chavez actually have a defense? This section shows how courts do try to be fair, even when the defendant's excuses sound suspicious, but a valid defense still has to exist for the case to go anywhere. Clip. The judge patiently explains what Chavez needs to get a second chance. First, he needs a valid reason for missing the hearing, which he arguably has with his internet issue. Second, he needs a meritorious defense, an actual, plausible argument against the debt. Chavez tries to claim that he just wants his due process, but the judge corrects him. Simply wanting a hearing is not a defense. It has to include real legal grounds for disputing the claim. The narrator highlights how this is a critical moment many sovereign citizens ignore. They think using buzzwords about rights and due process will stall the court or confuse the judge. But courts need evidence or real legal arguments. The judge makes it clear that Chavez is on thin ice if he can't produce anything substantive. The court's patience is evident, but so is its commitment to following the rules. Clip. The judge then turns to the actual legal question. This is a straightforward debt collection on a credit card. Discover Bank is the original creditor. There's no question of assignment or transfer. The judge reviews Chavez's written answers and finds they don't actually dispute having the card or owing the money. The legal standard in Michigan allows the court to rule quickly when there's no genuine issue of fact. The judge cites the rule clearly and announces that judgment will be entered against Chavez for the claimed amount. Chavez tries to argue. Further, mentioning affidavits, he wrote, but the judge explains that his written answers didn't raise any real legal challenge. The narrator drives home the lesson. Sovereign-style arguments about made-up finance theories don't work in court. Chavez asked for due process, and he got it. The court heard him out, checked the evidence, and ruled on the law.